Hello, and welcome to the Hardison and Cochran podcast. In today's episode, North Carolina Workers' Compensation Board-Certified Specialist Attorney Ben Cochran discusses two ways North Carolina workers' comp claims settle and how they affect an individual's ability to open their claim back up to seek medical treatment. Now, here's Ben Cochran.
In North Carolina, you usually see the resolution of your workers' compensation claim occur in two different ways. One is through a clincher agreement or a compromise settlement agreement, and then the other one is through the use of a Form 26A. If you've resolved your claim on a Form 26A, which means that you were provided compensation based upon your permanent partial disability rating, if you have a flare-up within 2 years from the last date that you received a check, you would be entitled to go back to the doctor and see your authorized treating physician for additional medical treatment. If you have an instance to where that's not happening and the insurance company is not returning a call to return back to the employer, then you need to contact an attorney to try and reopen your claim within that 2 years. Because if you do not reopen the claim within 2 years, then you will be barred from compensation further. In order to reopen your claim, if you contact an attorney, that attorney will have to file something with the Industrial Commission within those 2 years to establish that you are claiming additional medical treatment and potentially that you've had what is called a substantial change of condition. That would depend on the individual facts. If you'd like to do it yourself, you have to file something yourself with the Industrial Commission. A common mistake is simply contacting the insurance company and saying, I would like to go back to see the doctor, and you think that you've satisfied that 2-year requirement. Unfortunately, you have not. In order to reopen your claim within that 2 years, notice has to be sent to the Industrial Commission. And that it would be either through an attorney that you've contacted or yourself. You can do it yourself by filing with the Executive Secretary's office, indicating that you have contacted the insurance company and they will not send you back for additional medical treatment. So in that scenario, if you've resolved your claim with a Form 26A and you received your rating, if it's within 2 years of the last compensation that you were paid, you can contact either the Industrial Commission or an attorney to help you reopen your claim. The second scenario of resolution in the state of North Carolina is through a compromise or clincher agreement. In that scenario, more likely than not, you have completely resolved your claim such that it doesn't matter if it's 2 days after the Industrial Commission has approved the resolution of your claim or 2 years. In that circumstance, the compromise settlement agreement, it was agreed to by both parties that you are forever no longer claiming additional medical treatment and that you understood this at the time of the settlement of your case. Now, the reason for that being allowed and permissible is because more likely than not, you have resolved your claim through the use of this compromise settlement agreement for an amount in excess of a permanent partial disability rating. It is also required by the Industrial Commission that if you do have a compromise settlement agreement, that the amount is in excess of the permanent partial disability rating. So the Industrial Commission will not actually approve a compromise settlement agreement unless it meets a certain threshold above your permanent partial disability rating. And it's for that reason that you cannot reopen the claim after resolution through a clincher agreement.
We'd like to thank you for listening to the Hardison and Cochran Attorneys at Law podcast. If you would like a free consultation about you or a loved one's legal situation, please go to lawyernc.com. For a full list of episodes, please visit lawyernc.com/podcast.
Listening to this podcast does not create an attorney-client relationship between you and Hardison and Cochran. Hardison and Cochran does not accept new clients until obtaining a signed agreement. This podcast is for informational purposes only and should not be intended or taken as legal advice. If you have a legal matter, contact a licensed attorney in your state about your specific set of circumstances.